lawyer, and I work in Orrick's Silicon Valley office. Orrick is an international law firm. And about 4 years ago, I started representing a small startup called DJI, and out of China. And so in the last 4 years, we, starting from this client, we built a drone and unmanned vehicle robotics practice at Orrick. So now I'm co-chair of this practice. And Nathan is my co-worker. And today we're going to talk about top legal risks. And one of the sections is going to be on product liability. And he's a product liability specialist. He'll talk about that part. The only thing I can say about all the things raised by the other gentleman is that after lawyers got involved helping DJI, things are much better than before. I understand this morning Mr. Antonelli talked about compliance issues. So I won't get into that part, and I'm not a compliance expert anyway. I started out as an IP litigator, and now I deal with pretty much all the legal issues that's relevant to drone companies and robotics companies. So the only thing I want to mention is that if you're a drone company or a drone service provider company, just be aware other countries have different rules. Like we have several people working on drone regulation in our Paris office. So they told us that in France, the rules are much more stringent on drone, how they are operated, than in the US. Especially because in Europe it has a very much higher requirement on data privacy, and so the drones, they also need to follow data privacy regulation, which is what they call the Article 29 under the European Union rules. So for all the drone manufacturers or sellers, one of the things you probably won't think about, probably the thing you will see most, especially if you sell directly to consumers, are actually small claims. Not any big litigation, but just small claim court lawsuits that can make your life miserable, even though each particular one won't cost you a lot of money. And then product liability lawsuits, which Nathan will focus on. But one of the things that we can understand is that there haven't been that many large-scale product liability lawsuits in the drone industry yet. But as any new industry, they will come. After that is other consumer class action lawsuits. Consumer class action lawsuits based other than product liability. And patent infringement lawsuits. Also, for any, especially if you sell directly to the consumers, different types of trademark disputes. And for any company's contracts. So for small claims, example would be, let's say in California, you don't use lawyers, parties directly go resolve it, and it should be under $10,000. For a consumer company, it can be very painful if you are facing, let's say, 300 different small claims at different parts of the United States or in different locations. So for companies like Apple, or like what they learned is slowly they build a system to deal with all these without using expensive law firms. They tend to have an in-house department specifically dealing with small claims, how to settle it quickly, and how to use like a paralegals, just experienced paralegals supervised probably by a lawyer to deal with all the small claims. And most likely a small claim is based on product liability or on sales or service contract. Not much of anything else. So now Nathan is going to talk a bit about product liability.
Hi, everyone. So product liability refers to a lot of different and overlapping areas of law. and any definition of it, it's going to be both over and under inclusive. Who are the lawyers in the room? Okay, you're the only ones that will know that the definition I give, how accurate it is. But in general, what I'm going to talk about today is liability that arises from the commercial sale of a product that causes harm because it is defective. And this is something, when it's been broached again, that during Terry's presentation, when there is a lawsuit, when something goes wrong, when there is some defect, when somebody gets injured, who do you sue? And the correct answer in American jurisprudence is everybody. You may or may not ultimately be liable, but you're likely going to be sued if you are in what's called the chain of distribution, right? So everyone from the component part manufacturers to the manufacturer of the finished product itself, distributors, wholesalers, the retailers, can be held liable in, under products liability law. And traditionally, what a plaintiff would have to show is negligence, right? Negligence on the part of the manufacturer, right? That they did something wrong, that they failed to act with reasonable care. But in about the 60s, led by the great state of California, we came up with this idea of strict product liability, which basically says we don't care how good you were, company. We don't care how reasonable you were. We don't care how well you complied with the standards. If you produced a product and it is considered defective, we are going to hold you liable and make you pay for it. So again, in general, the company will be liable if the product or the component part is defective, and that can be defective in one of three ways, and you'd be do well to always be thinking about all three of these. The first one is whether there was a defect in the design. The historical example a lot of people know of is the Ford Pinto, right? Where the design of the car was such that, if I remember the facts correctly, if the blinker was on, the left blinker was on and it was hit from the rear, it would explode. At least that's the way it was in the Gene Hackman movie of the situation. More recently, hoverboards, right? Catching fire, exploding, Samsung's issues. There's a defect in the design that is causing some harm, and others are injured or there's property damage as a result. So here, manufacturers would be well advised to pay attention to things like your research and development, focusing on what is the state of the art. If now there is geofencing, and that is a good and practical thing for others to implement, and that is increasing the safety of the product, that is probably something you need to be paying attention to and implement into the design of your product, or other various safety features that others have spoken about today. The second kind of defect is a manufacturing defect. This is the very simple, the red wire just didn't get connected to the green wire at the manufacturing plant, right? And so that, as I say, can be a very unforgiving form of liability because, golly, through whatever process, the law doesn't care. Point is, it was manufactured improperly, and we hold the manufacturer liable for that to protect the consumer. The third area of defect is one we're all very familiar with, warnings defects, or more properly, failure to warn. We all know about this. We all know we need to have warnings because we live in this society where we have warnings on everything, right? Our hyper-litigious society has created this culture of over-warning to the point that, of course, we all have our favorite examples of warnings such as sleeping pills that say may cause drowsiness, right? Or I believe it was my son's Razor scooter said something to the effect of moves when in use. Yes, it does. And so, but because of that, right, that's something that we find clients are very focused on, like, oh, we need to warn, we need to make sure people know that this is a hazardous product. And that's right, you do. But a word of warning about warnings. They are certainly necessary, but they're far from sufficient. And so a lot of times people think of it in terms of, well, if I just have the right pieces of paper, right? If I have the right words in a user's manual and I have big, yellow triangles and I use the right ANSI standard language or other standards with red danger and orange warning and yellow caution and whatever it might be, then I can protect myself and shield myself from liability. Maybe even a disclaimer that says we don't have any liability. Those are all good things that one can and should do to protect themselves. But recognize that that is not going to protect you if there's a whole bunch of defects in the design of your product. So we always advise companies to take a very comprehensive approach. Make sure you are paying attention to all of these factors, doing your failures analysis tests, making sure the product complies with the current state of the art, and then, and only then, look at, okay, now what is left that we need to warn customers about, educate customers about, and generally contribute to the overall ability for users to be protected and third parties to be protected. And then Terry's going to like this part of the presentation. And I was talking to some folks over lunch that the ultimate takeaway when it comes to product liability issues is after everything you can do and should do and need to do, you're still going to be sued. And you're probably still going to be found liable at some point. So absolutely advisable to talk with somebody like Terry and protect yourself through insurance. One thing that comes up, lawsuits can be done in individual lawsuits. I think the Parrott lawsuit is just a single plaintiff suing several companies. But another way that often happens is a class action, right? Big, scary thing, it can be anyway. This is where something happens. For instance, there's defective software, the lost link doesn't work, somebody loses their drone. Well, that's the loss of a drone, okay? It's $500, it's $1,000. Not a whole lot of loss for the company to face. But if you get a class of 500 or 1,000 people claiming this loss, then you have a bigger problem. And so that's another thing manufacturers need to be thinking about, and the types of liability and the type of risk they can face.
So other than product liability class actions, there are other different types. One thing every single public company could face is a security class action, which is not particular to drone companies, so I won't talk about it. But for a consumer product company, let's say manufacturer, you will probably face false advertising, misrepresentation of a drone's capability type of lawsuit, the single lawsuit you are talking about, actually that one has something to do with false advertising in a video, right? But that one is not a class action, but it's a similar principle. And then if you have, nowadays with drone companies, I think one of those class actions that's going to come up, if not this year, in the next couple of years, would be inappropriate collection of data privacy violation based class action, because that one would affect every single drone user, consumer. That's probably more serious than, let's say you lost your drone. Among all the consumers, probably only 1% of them lost their drones. But everybody would have, data being collected by the drone. On top of that, data privacy is just how the data was collected, used, and transmitted and stored. But you potentially also have a data breach. Sony PlayStation got hacked, drones can be hacked, and then if drones are hacked, what data got lost? What sort of damages that could be? And then if multiple drones got hacked, or even the server that's storing the information relating to drone users get hacked, would there be a class action? Those things could come up in the next couple of years. I actually started out as a patent litigator, and being the ultimate geek working in patents, I'm used to, let's say, an audience like this, about 50 guys versus like about 3 women. That's pretty much the field we work in. However, patent infringement lawsuits haven't been very active in the drone space. It actually is somewhat unexpected. A lot of people were predicting there will be tons and tons of patent lawsuits. I have my own theories of why that happened. Potentially it's because there are not that many patents are owned by patent trolls, what we call the non-practicing entities. At this moment, about 60% of the patent lawsuits filed against companies in the US are filed by non-practicing entities. But the patents relating to drones, because the industry is so early, are either held by the drone companies themselves, or they are held by traditional companies such as aircraft companies like Boeing, or the companies that they deal with, wireless communication. Those companies, they are not getting into the lawsuits against, a small drone company. That can change as traditional companies start to offload their patents to non-practicing entities. We expect to see more like patent lawsuits. Well, the examples of patents that have been shown up in the lawsuits, there's a mobile app for remotely controlled drones. There is a lawsuit about tracking technology. There's a lawsuit about the obstacle avoidance, sense and avoid. And there's another lawsuit about in-flight maneuvering. And personally, I think there are a couple of areas that the patent infringement lawsuits are going to come up. Those will coincide with the hot technology areas where the drones, the technology are either developing or they're just maturing. For example, batteries. And a lot of times, at this moment, drones' capability are greatly limited by the battery life. So if the new technology are being implemented or created to greatly increase the drone battery lives, and if those patents are held, by a competitor or by a non-practicing entity, patent lawsuits might come up. Sensors. Sensors, high-grade sensors are critical for drones to fly well, especially now the drones are becoming more and more automatic. That is one thing that I might have a slightly different view from Mr. Trimble, that I think the drones are going to be more like driverless cars. They're going to become more and more automatic, regardless whether I agree with you, training for operators are important. But from a technology point of view, the drones are going to be, at this moment, the drones are just semi-automatic flying robots. They're going to be more and more like fully automatic flying robots. So the obstacle avoidance and the sensing technology and how to make it happen on a drone that's small enough, and how to detect and how to have the drones maneuver quick enough, because in the air you have to react faster than the driverless cars on the road. That area, I expect patent infringement lawsuits. So patent disputes can be many different levels. The easiest you will see is a cease and desist letter, for example, coming from a competitor saying, hey, you're using one of our technology, you need to either get a license or you need to stop it. And sometimes cease and desist letters will lead to lawsuits, sometimes not. Not every company, when they send you a cease and desist letters, they are fully prepared or have the financial resources to actually bring the lawsuit and execute the lawsuit. And then invitation to license letters. Those are slightly different from a cease and desist letters because they tend to be worded differently. Instead of saying, oh, you infringed one of our patents, you need to stop it, they tend to be very vague. They tend to say, you might find some of our patents interesting. You might consider licensing them. And those are likely more from non-practicing entities, and their business models is more likely to get you to buy a license. Sometimes they will bring a lawsuit if you refuse the license, but 80% of the times they don't. And then patent office proceedings, what we call IPRs. Let's say if you sue someone with a patent, sometimes the defendant will come back and bring an IPR proceeding at the patent office to try to invalidate your patent claims. And then if the defendant is successful, it ends up cancellation of the claims that are in the lawsuit. That may end up invalidate the entire patent or only part of the patent. And of course, we have the traditional district court patent litigation. And if the patent litigation proceed all the way to trial, actually only 10% of the patent litigation actually go to trial. But the end result could be injunctive relief for the plaintiff. So the defendant is injuncted, is stopped from selling, making, or using a particular technology, that could also have damages. Sometimes it's only injunctive relief. And then an ITC. ITC is International Trade Commission. That is really a lawsuit based on patent or trade secret, sometimes trademark, by one company against another from importing products infringing a United States intellectual property. But when you think about importing, you might think ITC actions is only from a US company against a foreign company. Not necessarily so. If you look at the ITC investigation, you might see a Korean company suing Apple in ITC because the Korean company has US patents and they also meet what they call the domestic industry requirement, means they have research development capability in the US, they own manufacturing plant in the United States, then they will meet the domestic industry requirement. They can bring an International Trade Commission investigation against a US company like Apple. But I guess Apple, you can call it an Irish company, but that's something else. For consumer product companies, sometimes they would forget. Patents may not be the most important thing. Sometimes it's the trademarks. Because trademarks means whether you have brand recognition, whether you can actually market and sell your products under a particular name. That is often also true with a service provider that sell to a lot of different companies. But I've, during my time representing a lot of the startups and the technology companies with consumer product and other high-tech products, I find that they tend to not pay enough attention to trademark because a lot of the founders are engineers. So then they tend to focus on patents. They think, I have a patent, we're safe. But then they end up finding that they can't sell their products, or they have been selling their products for 2 years under a particular name, but they didn't get a trademark. Or in that period of time, they are applying for the trademark, but by the time their products have already been in stores for 1.5 years, their trademark application to the trademark office is rejected. And then they have to change the names for their products. That can completely destroy that product sales for at least about 6 months. The reason it happens in the US this way, this is particularly a problem for foreign technology companies selling products in the US, is because in the US, trademark is by use, not by application. You get prior rights by using the trademark. Registration is just a part of it. After the registration, you can enforce against others. But because of that, like for example, in the European countries and Asian countries, people would remember to apply the trademark before you even sell your products. But in the US, because you can sell the products by using the name, oftentimes people don't do the application. And also in the US, the application process takes much longer than a lot of other countries. So they could be using a name for 1.5 years without having the trademark or gone through the trademark office, and then they have to deal with the consequences. So for trademark disputes, we also have the similar cease and desist letters, but unlike patent cases, trademark disputes often end up in coexist agreements, which means two companies, they have similar trademarks or the same trademarks, but they are in slightly different space. Their goods a little bit different. They talk to each other and they say, okay, I'm not going to use the word saying quadcopter. I would only talk about, helicopter. And by reaching some sort of agreement on the exact wording of their goods and services, they are able to reach some sort of agreement. Not as many trademark disputes become real litigation. But if, let's say, you have a trademark application pending at the trademark office, and then somebody doesn't like the fact that you are applying for this trademark because they have a similar mark they've been using or they own in a slightly different field, they can file an opposition proceeding at the trademark office. When they do that, if you don't deal with it properly, the end result might be failure to register the trademark. In joint opposition proceeding, a lot of times companies talk, they end up reaching, again, an agreement, a coexist agreement. Sometimes they cannot reach agreement, then they have to go through the opposition. And the trademark office oppositions are very expensive. Many people don't know that. Trademark office positions, they are like a mini litigation. They are not as expensive as patent litigation in the district court, but expensive enough that it's a real chunk of money out of your pocket. And then traditional district court litigation for trademarks. That would also include injunction, damages, and for trademark, often happens is that there might be seizure of the goods in violation. So for anybody who's thinking about trademark, make sure you conduct searches at the outset. Choose the right wording for the mark. Try not to use words that are too descriptive and too generic. Having the right language for your mark and create documentation to support use that will probably remove 80% of your future troubles. And then once you get a trademark, police the use, which means you have to enforce against people who use your trademark. Otherwise, you lose the right. There's something related to trademark, but not quite, with unfair business and trade practice lawsuit. And infringement of IP can be one legal theory upon which people can bring an unfair business practice suit, but there are also other things such as false advertising, trade libel. Like you say, my product is much better than others, that's okay. But if you say their product absolutely don't work, and then that's not true, that's a trade libel. And then every company would have contract lawsuits. And we think in the drone field, there will be contract disputes mainly because a lot of the drones now are custom for special use. When you have custom special use drones, and those, and a lot of times because there are startups working with startups, and their contracts are really badly drafted, and then at the end they would have a dispute. For the service providers, I'm talking about companies such as, for example, they do mapping services using drones for other businesses. They are drone, in a way, they are drone operators for commercial purposes. And they don't have the same type of legal risk as manufacturers. They would have much less risk on patent infringement lawsuits and trademark infringement lawsuits, but they would still have breach of contract lawsuits and product liability lawsuits. But because also they are operators, they have a much bigger risk in data privacy and a cybersecurity lawsuit risk. There's just one thing I'm going to talk about data privacy. I won't get into the details. I'll just give the 5, what we call the data privacy best practice. If you are operating a drone or you're manufacturing a drone, just remember, collect as little of a personal information of a user as possible. And if you collect, be very clear in your contract what you are collecting, how you are using it. And then third, after your collection, give the user a choice of how their information is used. For example, in many parts of Europe, the default is the user would not, you have to get user consent. And in the US, the default is reversed, but generally give users a choice. And then give user a chance to access the data you collected to correct if there's something wrong with it. And then the last is then be very transparent. Probably put it in the contract exactly what you're doing. If you follow those best practices, and then your risk relating to data privacy will be much less. Relating to data privacy, we mentioned is security, and I guess we don't have to get into that. The standard is that at a manufacturing level, use industry accepted technology to make sure you do the right thing for data security. If everybody is doing like 16-bit encryption and you're not doing it, then you would be much more likely be found liable in a lawsuit than the other manufacturers. And then at the operator and the service provider level, also, you want to use the industry accepted technology to protect the data, and you might want to consider using advanced technology because every country's requirement is different. You know, a lot of the European countries have higher requirement than the US. If you follow, let's say, the US standard, if you get into a lawsuit in another country, you might lose. You might as well, like, if it's technologically and financially possible, use advanced technology in protecting your data.
Well, I think we had covered some gold here. I think that a lot of the stuff that you're talking about in the next 12 months or maybe even sooner or later is going to be stuff that's going to be touched on as we move forward here. Any questions? Oh, we got one right over here.
I thank both of you for a great presentation. Can you speak to how a U.S. manufacturer or developer or operator can protect their own IP against infringements in other countries that don't readily honor the intellectual property rights, such as Russia and China? I know it's a long answer, but if you can speak to it real quick.
Okay, I think the best example would be Apple. You know, Apple does pretty much all the R&D in the U.S. They don't do the R&D in China. They do the manufacturing in China. And the Apple, because of it sets really, really strict requirement on its OEM, how they operate. And if you go to Foxconn factories, anybody who work for Apple are separated from the people who work for other Foxconn customers. That's how they try to ensure it. And the other thing is that for, of course, the country I know about the best is China, is that a lot of these countries, their practices are changing, mainly because they are also developing technology. As they're developing technology themselves, they improve on their IP protection. But still, when we advise clients, we would be very careful about, let's say, their in-house practices. Like in the US, to protect the trade secret, you often rely on things like agreements, employee agreements, and non-disclosure agreements, and exit interviews when employees leave. But in China, you want to have more than that. A lot of the Chinese companies, they don't allow anybody to print anything from their, some of the internal drives, and then you cannot download anything onto a flash drive. These sort of requirements would be considered extreme in the US. It's almost like, infringing upon your personal liberty. But in China, that's a standard practice in high-tech companies. You just can't do that. So that's how, people use different practices. You need to understand the differences and then just deal with it accordingly. Patents are territorial. Nobody in another country will recognize US patents. But if you want a patent protection, you apply a patent in that country. And actually nowadays there are more patent lawsuits filed in China than in the US. They're getting pretty litigious too.